My name is Sarah Stickney, and I'm the Dean of Reading Instruction at Walton Charter Academy in Pontiac, Michigan. And I'm here today to talk to you about student cell phone policy, and more specifically, I'd like us to take a look at how search and seizure rights apply to electronic devices in our schools. So to begin today, we have to understand search and seizure, and then also take a look at the policy that we have here at this school, and then combine the two to think about how we're going to go about search and seizure when it comes to cell phones and electronic devices in our school. So on page 23 and 24 of the Student Parent Handbook, it does state that cell phones are not permitted on school grounds or at school-related events unless approved by the principal. They shall not be used in a manner that disrupts the educational process or purpose, including but not limited to posing a threat to academic integrity, violating confidentiality or privacy rights of another individual, or violating the student code of conduct. If the principal has a reasonable suspicion that a violation has occurred, they do have a right to search for and confiscate the electronic device. So we're going to note here that it says that they can search for and confiscate the device. That's going to be important later. I think at Walton we've kind of had a don't ask, don't tell policy where we know that students have the phones in their pockets, but we've kind of operated under a policy that as long as we don't see the phone, then we're not going to be too worried about them. So let's think a little bit about what I'm going to call search and seizure light, because really these are just the basics of it, of the foundation that kind of makes up what we're about to talk about here. So this all comes from the Fourth Amendment of the Constitution of the United States. This amendment guarantees the rights of citizens to be secure in their persons, houses, papers, and effects against unreasonable search and seizure. Within this is the standard of probable cause, which basically means that the government needs to have a reasonable suspicion, and that needs to be supported with sufficient evidence. We see that take shape in the form of police needing a warrant before they can conduct a search and seizure. But we know we don't have warrants in schools, so how does this really play out in schools? And this has all been set in precedent by the 1985 Supreme Court ruling on New Jersey v. TLO. And in that case, basically, the Supreme Court said that school officials are agents of the state, and therefore they must abide by the Fourth Amendment search and seizure rights. However, the court did recognize that schools need to have some kind of flexibility or an ease of probable cause so that they can be able to maintain the discipline so the schools can continue to be safe and effective educational environments. So within this, they set forth a test of reasonableness. And really, when we talk about that, there's two questions that are asked, and we think about these when a search and seizure has been performed, or we can really think about it before we're about to perform it. And the first question is, was it reasonable at its inception? Meaning, was there probable cause that the search would warrant the evidence that is going to fit an alleged infraction or misdemeanor? The second question is, was the search reasonable in its scope? And really what this means is that the type of search that was conducted, is it reasonable given the circumstances? So what was the alleged infraction? How old was the student? What was the sex of the student? So when we're discussing reasonableness, we need to consider both the inception and the scope of the overall search and seizure. There's also a expectation of privacy rights within the Fourth Amendment. So when we think about the expectation of privacy, it's kind of like what in general in society, what level of privacy is expected. So different circumstances would indicate different levels of privacy. Here in Michigan, what's interesting to know is that, when it comes to lockers, the law states that lockers are property of the school, and so there's very little right to privacy. In fact, there's almost no right to privacy when it comes to lockers, and school administration can search a locker at any time. But when we start talking about needing to search personal items, the level of privacy increases. Again, when we, and it increases even more when we think about needing to search a student's person, their clothing, their pockets. So the higher the degree of expected privacy, the more you're going to need to make sure that you have probable cause, such as a severe misconduct or a threat of violence before even beginning to conduct the search. So now let's get into a little bit how this applies to cell phones. So think about what we just heard as far as the reasonableness of inception, the reasonableness of scope, and students' right to privacy when it comes to Fourth Amendment search and seizure. So the first scenario I have is that a staff, let's say it's a teacher, seizes a phone from a student that they see text messaging, and this is in line with a school policy that students are not to have cell phones. So upon seizing the phone, the teacher and the administrator begin to look at the student's text messages for evidence that other students may be violating school policy. So I want you to think about, given what we know, is this scenario, does it meet our reasonableness test? Would this qualify as a reasonable search and seizure? Scenario 2, the staff confiscates a student's phone, and again, because they were texting, and upon retrieving it, they see a picture of the student throwing gang symbols in front of their house. The picture then becomes evidence that the school uses to expel the student based on their school gang policy. So is that a reasonable search and seizure? So now let's think about that for a minute. Our first scenario, where the teacher took the cell phone and then they used it to try and catch other cell phone policy offenders. This is from an actual case in Pennsylvania in 2006, Clump v. Nazareth, which was the area school district. The family sued under Fourth Amendment rights, and the district tried to have the lawsuit dismissed. But the court found that they could not dismiss the lawsuit because the school had no probable cause to continue to search the student's phone, and they were simply continuing to just look for policy violators. And this is an invasion of that student's privacy. The second scenario that played out came from a case in Kentucky, GC v. Owensboro Public School. And what happened here was a student had a history of discipline problems. He had his phone confiscated, same situation after having it out in class, and the school had a no phones on campus policy. When they seized the phone, they found in its contents a picture of the student using gang symbols. Then the school moved to expel the student using that picture as evidence and basing it on their gang policy. The court found in that case that the school was outside their legal bounds because this search was unrelated to the original intent of the seizure, which was just the cell phone policy. The biggest one that we have to go on right now, the most recent precedent, and the one that I think is going to kind of set the tone for where we go in the future as far as search and seizure of smartphone devices, is Riley versus California in 2014. So this case did not involve schools. It was a criminal case, and upon arrest, the arresting officers took the defendant's cell phone. They looked in the phone without a warrant. They found evidence that was linking this person to other crime and tried to use it in a case, and it was thrown out. So the Supreme Court upheld that, or I'm sorry, I'm saying it wrong. The Supreme Court repealed the decision to be able to admit the evidence because it was obtained through an unauthorized cell phone search while the suspect was in custody. This case was big because it set the precedent that when you're placed under arrest, searching your cell phone is not covered in an officer's basic search, because their basic searches are really just meant to protect their safety, to make sure that the person being placed under arrest doesn't have any weapons or drugs on them, and then anything after that needs a warrant. The Supreme Court stated that, before cell phones, a search of a person was limited by our physical realities and tended as a general matter to constitute only a narrow intrusion on privacy. But the possible intrusion on privacy is not as limited when it comes to cell phones. So the burden then to justify searching a cell phone becomes higher than the burden that we have to search people's possessions. So how does this play out for us in schools? Well, I think when we combine Riley versus California with the New Jersey case, and then when we consider the Michigan Penal Code, which I'll read for you here, which states that a person shall not willfully or maliciously read or copy any message from a telegraph, telephone line, wire, cable, computer network, computer program, or computer system, or telephone or other electronic medium of communication that a person accessed without authorization. So when we combine all these things together, I think we're seeing a trend that it's going to be very difficult for schools to seize a student's cell phone and then continue to search it for evidence of other misdemeanors. So you really need to make sure as an administrator that you have good, solid reason to believe that a serious threat or violation of conduct has occurred, and that you have reason to believe that you will actually find that evidence upon search of the cell phone. So, my advice would just be that we need to be careful out there when it comes to students and their cell phones. A good rule of thumb is always try to get consent from students first. If a student says no and you have what you feel to be probable cause, then you can continue to search, but consent is going to get you out of that gray area. So let's go all the way back to Walton policy and remember that it states that you can search for and confiscate the phone, but it makes no statement as to searching the phone's contents. So phones really are like personal computers, and the amount of personal information on it increases, and that also increases the expectation of privacy. So the further you tread into that area, the higher your burden of proof, and I would just stay away from it if at all possible. So thank you for your time. And I'd like to just direct you to some of the resources that I use to find some of that information. And if you have any other questions, you can contact me.